Is this on? Okay. Hi. Good afternoon, everyone. Thanks for coming to this session. You are going to be part of the most extensive 401A2 session that EPA has ever done, new for this conference. So we're super excited to be able to talk about this topic because it is certainly very timely. I will introduce myself and then have the rest of the team introduce themselves. My name is Sarai Cohen. I am the Wetland and Ocean Section Manager at EPA Region 9, and we are the group that does Clean Water Act 401, 401A2. We co-regulate Clean Water Act 404 with the Corps of Engineers. We also do Marine Protection Research and Sanctuaries Act. So we regulate the transport and disposal of dredge material and the transport of everything but dredge material. So if you were at the Corps session, we actually talked to them quite a lot. So if you ever need to contact them, please contact us and we can help you out with that as well. So yeah, I'm going to have the rest of the team introduce themselves. And
Yeah. Hi, everyone. My name is Zoe Chan. I'm an environmental scientist in the Wetlands and Ocean section. I work primarily with the San Francisco District of the Army Corps of Engineers, and I'm also our 401A2 coordinator.
Thanks, Zoe. Hi, y'all. I'm Lauren Kasparic. I'm a biologist at EPA headquarters in Washington, D.C. Really excited to get to spend the afternoon with y'all. I'm the 401 team lead in our Office of Wetlands, Oceans, and Watersheds and work with our Corps headquarters counterparts on 401 issues, as also the lead for our recent rulemaking efforts. So if you have rulemaking questions, also happy to answer those as well.
Hello, everyone. Fadwa Buhada from Region 9 Wetlands and Oceans section as well, and part of the 401 team.
all right, so we'll get started. And do you want folks to ask questions during or hold them to the end? Okay, so I'll hold the other microphone, and if folks have questions and want to raise their hand during the presentation and ask questions, again, this is the first time we've ever done such an extensive 401A2 presentation, so we'd really like to get that information out there. So if you have questions, we know not a lot of folks know about this process.
Okay, get started. All right, so we can go ahead and get started now. So like Sarai alluded to, so we'll be going over the 401A2 process today, which is typically a process that happens after the certification decision is issued or waived. And what's unique about this process is that tribes can be a part of the neighboring jurisdiction process, even if they don't have tasks. So treatment as a similar matter as a state 441. And so we'll go over some insights as to why it might be an important role for you all and something you might want to consider down the road. So for starters, once again, the certifying authority in this case grants a certification either with or without conditions or waives a certification. And once that's completed, we move on to the 401A2 neighboring jurisdiction process shown here on the slide. This is a really important process just because the federal license, thank you. The federal license permit process actually cannot move forward unless the neighboring jurisdiction process is fully complete. So shown here is just a quick overview of the neighboring jurisdiction process, and we'll touch more on the certification decisions, notifications, EPA making a determination, notifying the neighboring jurisdiction, getting a public hearing set up, as well as the issuance of the final permit and license as we progress through this presentation. And so just to review the basics here, what exactly is a 401A2? It essentially is notifying a neighboring jurisdiction of the opportunity to either evaluate or object to an issuance of a federal license or permit. Particularly if a discharge is originating in another jurisdiction that will violate its water quality requirements. Oops. We also have, thank you. We also have the neighboring jurisdiction who is notified once EPA determines that a discharge from the project may or has a chance of affecting its water quality. And then it's also really important to note here that, the federal license and permit that initially triggered the notification, once again, cannot be issued unless this process is fully complete. So who exactly is considered a neighboring jurisdiction? Excuse me. Essentially, it's any state, tribe with treatment in a similar manner as a state for the Clean Water Act, Section 401 in its entirety, or only for the Clean Water Section 401A2, other than the jurisdiction in which the discharge will originate from, or will originate from. The map shown here is a typical example of a neighboring jurisdiction in proximity to an activity, a water body, as well as a jurisdictional boundary that's set by the certifying authority. And we'll touch in a bit on the different roles shown here on the slide that are involved in the process. So tribes with treatment in a similar manner as the state, also known as TAS, which I'll refer to throughout this presentation, for Section 401 or the 401A2, are given the status of a neighboring jurisdiction for the purposes of a Section 401A2. And with this new final rule, the new provision allows any federal recognized tribe to obtain tasks solely for Section 1, as well as obtaining tasks for the limited purposes of participating as a neighboring jurisdiction. So tribes who obtain tasks as a 401A2 alone are given the status of a neighboring jurisdiction for the purposes of the A2 process. And this is really important because once EPA makes a may affect finding during its determination, with respect to that neighboring jurisdiction, the notified neighboring jurisdiction, including the tribe with tasks for 401, can object to the issuance of the federal license or permit if they determine that this discharge will violate any of its water quality requirements, and can proceed with requesting a public hearing from the federal licensing or permitting agency. So what are some of the specific roles that are involved in the 401A2 process? So there's typically three, excuse me, first being EPA, right? So who essentially has a responsibility for notifying the states or tribes that are affected by a discharge from the proposed project or activity. EPA also has a role of evaluating and providing recommendations on any of the states or authorized tribes' objections on the proposed project. We then have the notified neighboring jurisdiction, who essentially is responsible for evaluating whether a discharge from another jurisdiction will violate its water quality requirements. And if it does, it will object to the issuance of this license and permit, and shortly after request a public hearing from the certifying authority within 60 days of getting that initial notification from EPA. And then lastly, we have our federal licensing and permitting agency, who is responsible for a couple things. First being notifying EPA within 5 days once receiving a certification or waiver and application for the permit or license. It's also responsible for holding a public hearing on any objections of a notified neighboring jurisdiction. And lastly, it needs to consider any recommendation of the notified neighboring jurisdiction and EPA, any other evidence that's presented at the public hearing. And so this is a really good flow chart that goes over some of the, excuse me, commonly asked questions on, what are the specific roles during the 401A2 process? So first being, a common question, does the certifying authority have a specific role in the process? answer is no. So the certifying authority doesn't have a role or doesn't have any obligations to consider a neighboring jurisdiction when issuing that initial certification. Another question is asked along the lines of, does a project proponent have a specific role in the process during the A2 review? No, but EPA is responsible for notifying the project proponent if it makes a may affect determination. And then does the public have a specific role in the process? Not necessarily in the A2 process, but with a caveat that once a neighboring jurisdiction objects to an issuance of a permit, it does have the right to put on a public hearing. And during that public hearing, that's when we have different folks involved, being one, the project proponent, any members of the public, and then of course the certifying authority that gets all together and kind of collects both the public and agency comments there. And then it's important to note, so the federal agency does have to consider any of the evidence that is brought up during these public hearings. So pretty critical step there. Okay, and then lastly, just going over the neighboring jurisdiction process. I'm going to walk over this briefly, but I know Zoe and Lauren will go into this more in detail in the following slides. But essentially, you have your process starts when the federal agency receives both the application and a certification or waiver. That federal agency has 5 days to notify EPA. EPA then has a ticking time clock for 30 days to essentially notify any of the neighboring jurisdictions if it thinks that any of the, determines that any of the discharge from the project could affect the water quality. And once the neighboring jurisdiction has that notice, it has 60 days to determine whether the discharge from the project will affect its water quality and if it will violate any of its water quality requirements. That's when the federal agency's public hearing is also scheduled during that time frame. And the federal agencies must wait to issue the license or permit until the process is fully completed. And again, so the federal licensing or permitting agency outcome from all of this is heavily based on, what was given upon recommendations of the neighboring jurisdiction, EPA's insight, as well as any evidence that was presented at the public hearing. And I guess I'll hand it over to Zoe now.
Thanks, Fadwa. Okay. Oh. Okay, cool. Are there any questions while they're rebroadcasting? No? Okay. Oh.
So the folks online can hear you.
Will the PowerPoint be available afterwards? I've been looking into Excel events and I can't seem to find, they say like recording sessions, but I want to take what you have in your PowerPoint and give that to our legal counsel.
I'm going to pass this off to our headquarters, maybe answer that.
Yeah, we should be able to. We sent our slides in late, so I think that might be why it's not on there yet, but we did submit them this morning. So they should be accessible, and we can also follow up afterwards to make sure they get circulated.
Thank you.
Okay. Are we rebroadcasted? Awesome. Thank you. Yeah, so as Fadwa mentioned, the first step in the neighboring jurisdiction process is notification to EPA. So that's when the federal license or permitting agency notifies EPA. And so what triggers this notification to EPA? That's when the federal license or permitting agency receives 2 things. The first is the license or permit application, and the second is an associated water quality certification or waiver. So when they have both of those things, they have 5 days to notify EPA and begin the neighboring jurisdiction review process. I'd also like to highlight that this applies to all 401 certification and waivers on federal licenses or permits. So some examples could be like FERC licenses, EPA issued NPDES 402 permits, as well as 404 general permits, which the folks at the Army Corps issues. So those are just some examples of different federal license or permits that may be notified EPA for our review. So for the purposes of this presentation, we're going to try and build a picture and create a hypothetical situation for a 401A2 review. So let's pretend we have a proposed copper mine development on federal land. And as part of that development, there will be road crossings, as well as a berm to store mine tailings, as well as stormwater. The stormwater will be treated on site and then discharged into the waters of the United States. And this project is located 20 miles upstream from a tribe that just received treatment in a similar manner as a state for neighboring jurisdiction. So they are considered a neighboring jurisdiction. Additionally, based off the project description, they're going to need at least 2 federal license or permits. The first is a Clean Water Act Section 404 permit that the Army Corps will issue, and the second is a Clean Water Act Section 402 permit that EPA will issue. So once these federal agencies have received application for their associated permits and they've received a certification from the certifying authority related to their permit, they need to notify EPA within 5 days and basically say, we got these things, let's start the 401A2 process. And so there are 4 components that they need to include when they notify us. The first is a copy of the certification or waiver. The second is a copy of the application for the federal license or permit. And let's say, in scenarios where there isn't an applicant for the federal license or permit, they can provide like a draft permit. And the third piece is a general description of the project. And the fourth piece is a copy of the comments from the neighboring jurisdiction. So this is a really important part. And these are comments that a neighboring jurisdiction can provide during a public notice period. These can be outside of a public notice period comment, but the federal agency needs to provide them for EPA. So framing that within our hypothetical copper mine development, let's say the tribe that is 20 miles downstream of the proposed copper mine sends an email to the Army Corps of Engineers and expresses concern about the discharges associated with that project. They would have to include those comments in their notification to us. So it's a really great way to start early coordination if you have a project on your radar that you're concerned about that is outside of your jurisdiction. Okay, so once EPA receives the neighboring jurisdiction notification, it starts our 30-day review period. And so when EPA receives the notification, they basically have 30 days to determine whether the discharge from the project may affect the water quality requirements of a neighboring jurisdiction. So I'd like to highlight here that our review is focused solely on the discharge associated with the project. And also, we're only, reviewing it for a may affect determination. We're not going as far as to say, this will affect neighboring jurisdictions' water quality requirements. So for the purpose of our hypothetical copper mine, the question that EPA would be asking is, does the copper mine development, the discharges associated with that, have a potential to affect a neighboring jurisdiction's water quality? And so how do we do this? And so how do we what factors do we consider when we're reviewing this? So this is not an exhaustive list of what we review. This is just some of the examples that are pulled from the preamble of the most recent 401 rule, are some of the things that we can consider. I want to highlight that the 401 rule and the regulations don't require us to look at all of these for one project. It's really on a case-by-case basis. So let's say, for example, let's see. Yeah, it's not exhaustive list, and we're not required to look at these only 7 and review them every single time. And let's see, every single time. And then, yeah, I also want to highlight, another factor here that is considered, which is factor 5, which is the neighboring jurisdictions' water quality requirements. So I wonder if anyone in the crowd would feel comfortable like sharing a water quality requirement of theirs right now. We have one hand.
We have water quality objectives of a healthy riparian environment that includes willows, sedges, and tules.
Thanks.
Yeah, so that's a really good example of a water quality requirement. It can be, tribal regulations or ordinances that are associated with like riparian habitat or cultural uses of water. Is another really great way. That is another water quality requirement. So that's something that we would consider. Okay, so let's say for the purposes of our copper mine hypothetical, EPA reviews the water quality certification, the federal license or permitting application we have, any comments that the neighboring jurisdiction provided, and the project description, and determines that the project may affect the water quality of the downstream neighboring jurisdiction. This is when, we kind of pass the baton to the neighboring jurisdiction. And what we do that by notifying them, as well as the federal agency and the project applicant. And we say, hey, we've made a may affect determination for this project. And that's when we say, neighboring jurisdiction, this starts your 60-day evaluation. So the neighboring jurisdiction has 60 days to evaluate if the project will violate their water quality standards, object to the permit, and request a public hearing that the federal agency will organize. And so I want to note here that the 2023 rule and the 401 regulations do not define what a will violate standard is, nor does it define the factors that a notified neighboring jurisdiction needs to consider when making its will affect evaluation. But I want to note that when we're thinking about the discharge of the project, when you're making your evaluation, it can be that, we think the discharge will violate our water quality, or you can also say, like, we think that the discharge will help contribute to a violation of our water quality requirements. This is also another really great opportunity during this 60-day period to work with your federal agency. So, maybe you have concerns about the project, but you think there are ways they can be alleviated through conditioning. You can have, conversations with the federal agency about how they can include that in their federal license or permit. That's a really great way to kind of initiate that process. In terms of like working with the certifying authority, unfortunately, like as Fadwa mentioned, the certifying authority, they've already, done their part and written the water quality certification. So during this time, it's maybe not be the most fruitful to work with them because their process is kind of done. But the 40182 process is really hosted within the federal agency. So let's say for the purpose of our wonderful copper mine development, the neighboring jurisdiction reviewed it and determined that, we think that it will violate our water quality requirements. They coordinated with the Army Corps of Engineers and the other federal license or permanent agencies associated with the project and, expressed their concerns. Their concerns couldn't be addressed within the 6 period, so they decided to move forward and object to the federal license or permit and request a public hearing. And so now I'll pass it off to Lauren to touch a little bit more about the objection process.
Thanks, Zoe. All right. So like Zoe said, we're going to assume in this circumstance that we're the neighboring jurisdiction and we determine that this particular discharge will violate our water quality requirements. So we want to object to this particular license or permit. In making that determination, the notified neighboring jurisdiction needs to contact EPA and the federal agency. And there's 3 things in particular that have to be in that notification registering your objection. So first, you see listed left here, there needs to be a statement that the notified neighboring jurisdiction is objecting to the issuance of the federal license or permit. Like Zoe noted, something I'm going to focus on here a lot, and you'll hear us reiterate a few times, is this process is focused on the federal license or permit. So the certification, the certifying authority, those aren't necessarily relevant to the conversation we're having now. The question is, and the thought we have here is we are objecting to the actual federal license or permit. Second, in the middle, and this is actually the most important thing that we're going to spend a few slides talking about, is the notification must include an explanation of the reasons supporting the neighboring jurisdiction's determination that a discharge from the project will violate water quality requirements. And this rationale needs to include, but is not limited to, actually identifying those water quality requirements that will be violated by the discharge. The last thing that you see all the way on the right here is that the notification also needs to include a request for a public hearing from the federal licensing or permitting agency. And we'll talk a little bit more about what that public hearing process looks like and ways that you can actually avoid it if you are able to do, like Zoe said, able to come to some sort of understanding or address concerns earlier in the process. All right. So I mentioned that the most important part of the notification, both for EPA and for the federal licensing or permitting agency, is the reason behind the notified neighboring jurisdiction's objection. Now, as we'll say in a few slides, we'll go through in a few slides, the reason why this is the most important part of your notification is because this is what EPA is going to focus on when we're doing our evaluation and recommendations on the objection, and also what the federal agency is going to focus on when they're trying to determine what they're going to do with the objection. Now, we saw on the last slide, this was the second component listed on the last slide, the objection must include an explanation for the reasons supporting the neighboring jurisdiction's determination that the discharge or a discharge from the project will violate water quality requirements. And aside from requiring the neighboring jurisdiction to actually identify the water quality requirements that will be violated in this particular scenario, the rule itself doesn't actually define what else you need to include in this portion of your objection. However, we do have some recommendations about the sort of things that'd be helpful to include in your objection, including, identifying the additional information that you use to support your determination, such as, identifying the receiving waters where the water quality requirements will be violated, identifying if there are any conditions that if you included that in the project, if it was included in the permit, it would address your concerns, or similarly, if there are no conditions that would address the concerns in this scenario. You can also provide other evidence to support your objection, such as, let's say, if you have some sort of monitoring data for that location, you could send to us, any data about the affected water body. Let's say in this case, it's copper mined. If it's an area that's had, let's say, legacy pollution with mines in particular, maybe you have past experiences with these types of discharges and negative impacts on your water quality you can point to, potentially have maps, etc. I mean, ultimately, what you really want to focus on here is clearly explaining how and why a discharge will violate your water quality requirements. So in this scenario, like we said, we're talking about the copper mine. If we do object to this particular license or permit, we're going to want to make sure we're included information about, do we know anything about the water quality in that receiving water, in our jurisdiction? Are there particular concerns we have? Maybe we have certain standards or we have cultural uses that have been incorporated to our water quality requirements that we are concerned that they will be impacted. Maybe we have impaired water bodies already there. Going back to the point about something contributing to further pollution, maybe we already have impaired water bodies that we're concerned would be impacted by the discharge from this project. So definitely keep in mind, more information is probably better so that we have that information before us in our analysis, and also so the federal agency has it before themselves in their analysis. All right. So if a neighboring jurisdiction objects to the issuance of a federal license or permit and requests a hearing, the federal licensing or permitting agency is required to hold that hearing unless the objection is withdrawn. A neighboring jurisdiction can withdraw their objection at any point in time prior to the public hearing happening. And you may be asking yourself, well, why on earth would a neighboring jurisdiction want to withdraw an objection? And it may be because, like Zoe was alluding to, the neighboring jurisdiction might be able to resolve their objections they have before getting to the hearing stage with the federal agency. So I'll actually use a lifetime example that we've had. We've only had 3 projects go fully through this 401A2 process in the last few years. And we've had scenarios where it was actually a tribe in one situation where they and the Corps met, discussed the concerns that they had, and ended up withdrawing. It was like 8 of the 9 objections they had on that particular permit because the Corps had agreed to address their concerns as permit conditions and how they were doing the project. So folks try to use that period of time before the hearing to really talk about what their concerns are, work together for how they might be able to address it. So we definitely encourage folks to have that open, often communication throughout the whole CERT process, but especially at this stage in the A2 process. And ultimately, being able to withdraw an objection, that allows the neighboring jurisdiction to conserve their resources that would otherwise be expended to actually participate in and engage in the public hearing process. Now, what happens if you do withdraw? All that happens is the neighboring jurisdiction at that point will notify EPA and the federal agency in writing that they're planning to withdraw their objection. The public hearing will not be held, and at that point in time, the license or permit is able to move forward through the rest of its process. For purposes of our hypo, we're going to pretend like maybe we talked with them, but we still have some concerns about it. We feel like our objections aren't really being addressed, and we haven't seen conditions or changes that would address our objection for this particular copper mine. So we're going to go ahead and move to the public hearing part of the 401A2 process. And I'm going to talk about what that hearing looks like, what occurs during it, what EPA's role is, and then lastly, we'll wrap by talking the so what happens after the hearing occurs. All right, so as I noted, if the neighboring jurisdiction does not withdraw their objection prior to the public hearing, the federal agency is required to hold that hearing. And I do want to note that it is the federal licensing or permitting agency who is responsible for hosting this hearing. EPA would not be the one hosting it unless, of course, if it was an EPA-issued permit, like our Section 402 permit, that would be an instance where we'd be responsible for hosting it. But otherwise, let's say it's an Army Corps of Engineers permit, like we're talking about in this hypo, the Corps would be responsible for hosting that public hearing. Now, question we often get when we get to this point in time is, okay, well, when does it actually happen? And how on earth am I supposed to know that this hearing is coming? And we did put some requirements in the rule that requires the federal agency to provide public notice at least 30 days prior to the hearing that the hearing is coming. As part of that process, the public notice must go to interested parties, which we have defined to include the notified neighboring jurisdiction, the certifying authority, the project proponent, and of course, EPA. Now, we did not define in our rulemaking what type of public hearing the federal agency has to hold. We do defer to the federal agency to use their process for public hearings. However, we do have some recommendations that we've provided in our rule, in our preamble for federal agencies, including recommending that the federal agency accept public comments and additional evidence on the objection, and also that the federal agency take into account the ability of interested parties to participate in the hearing when deciding where the hearing will be held or the method for the hearing. So one of the examples that we've run into, in one case for a tribe in particular, it was really important to them for the hearing to occur on their reservation so that they were able to attend it for the entire period. And so they shared that with the Corps and asked them to make sure they considered that. They also asked if they could make sure that folks could virtually attend it. So I know some of my regional colleagues in that situation, they attended it virtually. So those sort of things we encourage the federal agency to think about to make sure they're able to accommodate the interested parties and ensure they're able to fully participate. Now, at the hearing itself, of course, what happens, it depends on the hearing process. So we anticipate that there will be a venue for folks to provide comment or testimony at the public hearing. To date, when we've gotten to this stage in the 401A2 process, at all 3 of them, there have been opportunities for folks to provide oral comments at the public hearing and also provide written comments after the hearing. So again, it'll be up to the federal agency to decide how that works, but those are recommendations. Aside from input coming in through that, EPA also will be providing its evaluation and recommendation at this hearing. So I want to talk a little more specifically about what EPA's role is during the public hearing process, because we do have a very specific role. There's actually a statutorily defined role that EPA has in the A2 process. And that is, we are responsible for objectively and neutrally evaluating the neighboring jurisdiction's objection and providing recommendations to the federal agency based on our analysis of that objection and the record before us. So as I mentioned a little bit earlier, we're talking about the components of the notification that is you as a notified neighboring jurisdiction would be sending forward on the objection. It's really important for a neighboring jurisdiction to clearly explain the reasons supporting its determination that a discharge from the project will violate water quality requirements, because that is exactly what we're evaluating and we're looking at. Another reason why it's really important to make sure that you have the information and evidence there to support the determination in your objection is that during this process, because we are in this more neutral role, EPA does not seek input from the neighboring jurisdiction or from the public as we're conducting our evaluation process. I do want to caveat that with, of course, if we have questions about a neighboring jurisdiction's objection, we will consult with them and talk with them and ask for clarification on, like, what did you mean? What was this data source, etc. But ultimately, EPA is responsible for making this evaluation and then presenting this evaluation and any recommendation we have at the public hearing itself. So once the public hearing occurs, and as I mentioned, that's the point in time where EPA will provide its input on its evaluation recommendation. If the notified neighboring jurisdiction say that they want to come forward, so let's say in this case in our copper mine, as a notified neighboring jurisdiction, we want to reiterate our position and our concerns about the project, we would also be at that hearing. I will note that we've also seen project proponents come and provide testimony at the hearings. Sometimes folks, after EPA presents, will come back and either rebut it or add other information to it. So all that will happen at the hearing. And then ultimately, the federal licensing or permitting agency is then in the driver's seat and responsible for actually considering the recommendations of the notified neighboring jurisdiction, EPA's recommendations, and of course, any additional evidence that was presented at that hearing. And ultimately, the question before the federal agency is determining whether or not a particular activity or a particular license or permit will comply with the neighboring jurisdiction's applicable water quality requirements. Now, I did just go on the last slide, talked a little bit specifically about EPA's role, but something I do want to clarify here is, the Clean Water Act itself doesn't accord any sort of special status to EPA's evaluation recommendation as compared to the other evidence that's presented at the hearing. So ultimately, when the federal agency is doing their evaluation after the hearing is over, they are supposed to consider all the information before them equally, right? So our input that we have in our evaluation recommendation, the notified neighboring jurisdiction's objection, and of course, any other evidence that came forward. Now, when it comes to how long does this actually take, how long do you have to wait to hear what's going to happen next? Unfortunately, the statutory text does not provide us with any time limit, and neither does our regulation. I can tell you that, at least for what's happened to date, it has taken quite a while. So in both of the two of them were tribal objections in particular. It took the Corps a year to act on the objections and decide what they wanted to do. In another case we had, it was a 402 permit. It was between some states. It took about 6 months for EPA in that instance to actually decide what it wanted to do in the process. But just flagging that, there is it's an unknown there for how long it will take. And there's several possible outcomes that can come out of this. So first, the federal agency may consider their information and determine that they feel like there is nothing else they need to do to ensure that the activity will comply with water quality requirements. They can determine perhaps that maybe additional conditions are necessary to ensure that water quality requirements will be met. And in that case, those conditions must be included in the federal agency's license or permit before they can issue it. And lastly, they can also end up evaluating and determining, there are no conditions we can place on this project to determine whether or not, or to actually ensure that water quality requirements will be met. And in that instance, they cannot issue the license or permit. Again, to date, we've actually had one scenario where that happened with the tribal reservation, I guess about a year ago, 2 years ago, where the court ultimately decided they could not issue the permit in light of the objection, and the project did not go forward. I do want to take this moment to also flag, one of the things I noted is that they could also decide that conditions are necessary to put on the license or permit. As a notified neighboring jurisdiction, as I noted earlier, when you have, like, you're putting your objection forward, one of the things you can do is recommend conditions that you'd like to see in the license or permit that would address your concerns. EPA, when we do our evaluation, we also at times have recommended conditions too that we think may address concerns. And so the federal agency will consider those. There's no guarantee they will take it verbatim. The federal agency does have a lot of discretion in this process versus for those who are familiar with the certification process, they don't have discretion to pick and choose conditions. They have to take them as they are. But in the A2 process, it's a little bit different. The federal agency has more discretion, but they do have to consider that information before them. So it's definitely worth, as you're going through the objection, if there are conditions you think may be appropriate or able to resolve the objection that you have, putting those forward and starting that conversation with them prior to the hearing to see if you can address your concerns is important. And so I know there's another task presentation's actually happening right now, I believe, that may touch a little bit on this, but I'd be remiss not to mention this in this discussion because, one of the reasons why we're talking about A2 and we've done this presentation specifically is because we did create a new provision in our rule last year, as Fadwa mentioned, that specifically allows tribes to take on tasks for this process that we just went through, the Section 4 and A2 process. So tribes have the opportunity, of course, to participate in this process by obtaining tasks for all of Section 401, right? So you can obtain it for all of Section 401, or if you get TAS for water quality standards, there's an option there to also opt into 401. But there's a new process to opt in to just TAS for this Section 4 and A2 process that we just talked about. And I wanted to share, we have these QR codes here. So we have application templates that are available for folks online. On the left side is our application template for TAS for the entirety of Section 401. And on the right, the templates for just 401A2. And just to give a general flavor of what is in here, there's 3 main sections in both of these. So the first section just provides more background on each of these, like what is Section 401, Section 401A2, what does it mean to obtain tasks for these provisions, a checklist for the application, as well as the responsibilities that come with getting tasks for both of them. The second section of these materials is actually the template itself. So there's like blue text in there that shows where you'd plug in the information. And once you fill that in, you actually have the application ready to go. And then the third and final section of these materials are the actual instructions for using the template. And this includes additional resources on components of the application and the application review process. And I will note, for those who have gotten tasks for other programs, like let's say 106 or 319, the materials, or like the cool part about the task process in the Clean Water Act is the requirements are the same. There's certain fundamental requirements that are the same across the board in the packages. And you can reuse those materials as part of your task package if you want to just come in for 401 or 401A2. The only difference is there's a requirement to show, what your capacity is or capabilities to take on that program that requires more specific information that would be tailored to 401. But let's say you already have it for 106, you're going to already have that basic information about your authorities, legal abilities to take on the program, et cetera. So I did want to flag that for folks. And I think that might be all of our slides. Yeah, I have a QR code here to the 401 website generally, which has all the things and more. We'll not have this presentation, as Sarai mentioned. This is actually the first time we've done this presentation, so we're really excited to go through this with you guys. But there are other materials that are up on the website, including trainings, the templates I just flagged for you guys, some great fact sheets, and of course, contact. Oh, wow, that's tiny. Okay. Okay, well, if you had a magnifying glass, you might be able to see this. I promise. There's contact information there, and we really do want you to contact us. I don't want anyone to misinterpret the baby text. But the top one is the inbox for 401, so CWI401 at EPA.gov. Yours truly checks that inbox. I promise it's not a robot there. And then, of course, Zoe is the 401A2 coordinator for Region 9. She can answer all your questions and then some. So we will be sharing these slides afterwards, so you don't have to squint. I can't even read this either. So you don't have to squint at that. I'll go back to the other one because that's just embarrassing. But if you guys have any questions or anything we can clarify, I'm more than happy to answer those questions, but really excited to spend, like I said, this afternoon with y'all walking through this. So I want to open up to questions, or if there's anything you want us to go back to walk through, happy to do that as well.
I know it's late in the day, so I'll just try to keep my question more general. I described a water quality objective that we have in the tribes, like our non-point source plan and other planning documents. But as you describe a requirement, I guess we at this point we don't have water quality standards, and we see this as being a process we can complete before the water quality standards due to the time. And is it possible for us to describe narratively, because at this point we just have narratives in, I described that we want to have a quality riparian environment. Could I state that because we're concerned about the sedimentation that may come down from an upstream project. Do I need to indicate, because how would you tell if it violates until the willows die or the sedges don't emerge? Would I have like a turbidity level or a TDS? If I say that at this turbidity level, I would think it would cause sedimentation, can I describe that narratively, or do I need several years of data to kind of back up that, or can I refer to literature? How much do you need to, how much scientific backing do you need for your requirement?
That is a fantastic question. I just have to say that up front. So I want to start with the water quality requirements piece of it first. Water quality requirements is a specific term in 401 world, and we do expect, so it's anything for meeting the requirements of Clean Water Act sections 301, 302, 303, 306, 307, and if there's any tribal regulations you have implementing those sections, like implementing standards or implementing toxic pollutants, that'd be included. But it also can include any water quality related requirements of tribal law. So if you have a tribal ordinance, so you're mentioning a plan that you have, if it's somehow captured in a legal instrument, it's a treaty, it's an ordinance, it's in tribal code, that is okay. That is a water quality requirement. You do not, as you touched on, you do not have to have EPA approved water quality standards. That is a one type of a water quality requirement, but that is not the only one. In fact, let's say you have water quality standards for your tribe that EPA hasn't approved, but you've promulgated for purposes of your tribes. That is a water quality requirement that could be considered as part of your analysis for 401A2. So, and actually, let me go back to, because I want to get to your other question you had about, what do you actually need? Because honestly, that is, as I mentioned, that's the most important part of this when you're doing your objection and what's there. And there is no, of course, there is no threshold of like, what is perfect, what is enough, right? Like I can't give you like an absolute of like, if you have X number of years of data, that's perfect. But what we have seen that has been very helpful and useful in the process is folks will provide us their water quality requirements. Here's my turbidity level that we're supposed to be meeting here. Maybe you have modeling, maybe you just have some data in that area. I've had a year or so of data, or I've seen this project happen here before. Providing us with that information is very helpful. It's up to you to really figure out how do you want to craft and support, like, again, you're trying to support the bottom line of, will this discharge violate my water quality requirements? That term will violate, that's a high term, right? Like that's, you're showing like this is going to happen. EPA, when we're doing our analysis, we're just saying, okay, may it affect your water quality. But there's another level that happens for the neighboring jurisdiction of looking at it and say, no, like we're looking at this, like this is gonna violate our water quality requirements. Maybe we already have impaired waters here. It's already impaired for this particular criteria. Adding this to it is gonna make it worse. It's not gonna make it better. So using literature is also great. That's very helpful if you're able to point to certain literature about here's how this pollutant moves. We've seen it moves XYZ way, maybe it bioaccumulates. That sort of information is very helpful to include in your objection itself. So it seems like you're flagging all the right stuff as part of the process. And as I mentioned, I mean, EPA is part of our evaluation. Like we look at that, right? Like we're gonna look at that. If there's maps, flow charts, like anything else, we will look at to say, okay, like, what does it look like? When we're evaluating this, like, do we agree? Like, yep, this will violate those water quality requirements. And then at that point, make a recommendation of what we think the federal agency should do at that point.
Well, thank you. I just want to give you we're working with FERC on this. They're looking at decommissioning a dam upstream of us. So it sounds like more commonly you probably work with the Corps or wastewater plant discharges, but yes, for.
Yeah, so far we've seen, it's been, like I said, it was 2 404 projects. And then there was one that it was technically a dam. It wasn't a decommissioning. It was a 402 permit on a dam. So a little bit different. But, any federal licensing permit can end up going through this process. So it's a whole world in front of us, I think.
Yeah, I would say for Region 9, the majority of 401A2s, and we look at hundreds of them in a year, are for 404 permits from the discharge associated with that. But we have seen FERC licenses, and we recently did a whole bunch of 402. So could be lots of things, especially FERC. Sometimes they have this thing called a preliminary permit, which is not a permit. It basically holds their spot in line. You know, they're getting a spot holder in the line of processing. But that's one way that we sometimes know ahead of time about what FERC actions might be coming along.
That was a great question. Super bonus points for that because it's a really great question. Oh no, it's okay. Yeah, we're excited. If you can't tell, we're jacked for this.
So I might have missed this, but how do you define neighboring? Because you said like 20 miles downstream in your hypothetical. Does it matter if there's different jurisdictions in between? Is it, neighboring is a very broad term to me. And I was just like,
Yeah. No, you are spot on. It is a very broad term, and actually it is defined broadly in the regulation. So we do define it as any state or tribe other than the jurisdiction that issued the certification. So when it comes to EPA, again, what we're looking at, first is there a jurisdiction other than the one who issued the certification? Are they eligible to be a notified neighboring jurisdiction, right? So is it a tribe that has tasks for 401 or 401A2? And then at that point, our evaluation or analysis is just, may a discharge affect the water quality of the neighboring jurisdiction? So we have actually, one of the A2 cases I was referring to, the discharge in that case was 80 miles upstream from the neighboring tribes. And we did go through, the permit was not issued in that particular instance. So distance is not always, it's one of the factors we mentioned. There's several factors we look at when we do our analysis. One of them is, of course, distance is one of them. I think it's the second one, proximity of the project and discharge to the neighboring jurisdiction. But of course, as Zoe mentioned, that's not the only one. We may look at different factors. It really is case specific. What is the type of pollutant? What are the other factors present, et cetera? So that's a great question and awesome. You guys are like, it's like late in the day. You expect people like not to be like on it. You guys are like on top of this, picking up on this. So I really appreciate these questions. Other questions? The other attendees didn't mean to put the pressure on y'all, but.
That's overtime, but I did want to slip in one more. I was going to ask it separately. Our tribe has 2 truss locations downstream of this dam decommissioning. One's 4 or 5 miles away. And I think I described to you the other day, the PG&E or whoever originally built the dam owned the river itself and kept us out. So when the tribe took the land into trust, we were only up to the high water mark for regular flows. But their flood flows do go into our property. Downstream, we have another trust property that goes halfway into the river. So we do have trust waters, but it's more 10 miles down or 15 miles down rather than 4 or 5. So I think we could still reach this level of involvement. But the closer properties, it floods. When it floods, it goes into our land. So we don't technically have any water there because they kept the river. Can we be the neighboring jurisdiction? Can you have, because we don't want the mercury. We're concerned about mercury, PCPs getting deposited in our riparian areas that's land next to the river.
Yeah, so another great question. So of course, I can't speak to specifics and like offer any guarantees or absolutes. I mean, I will note abstractly that the analysis is limited to like water quality effects on your receiving waters that you have. Our jurisdiction does not stretch into, of course, like land itself or like upland areas, but of course, it's going to depend on the specific situation about where the waters are, where any particular discharge might occur. So it might be something that'd be helpful to talk about more directly with our Region 9 colleagues if there is like a fact-specific pattern about whether or not is there a water body in that instance where we may, if we get a particular license or permit in that instance, may we make may affect. And I don't know for my Region 9 friends, if you guys want to talk at all about how you guys typically engage with tribes in the A2 process, like when you get notices in, if that's something you guys can speak to.
Yeah, so I'll address that. So I'll flag 2 things. One, Zoe, I believe, tried to really emphasize that one of the things that the federal agency needs to provide us with is any comments from the neighboring jurisdiction. So this would be a fantastic opportunity if you know that this permit is being considered, that you send them comments that say like, we have a concern about these 2 areas, because that will get to us. I mean, you can tell us directly, you could email our inbox and Zoe will get it. And so that we would know ahead of time, but that is, we do get hundreds of these a year. So like, we really need that information we only have 30 days and it can't be extended. We have 30 days to figure this out. So one of the things that we have typically done for when we're trying to figure out a May effect is that we will go talk to that neighboring jurisdiction. So I will likely call you up and say, we got a notification. We know that you're concerned about mercury because we got your comments. Can we talk to you more about it? What are your specific concerns? What's the analysis that you guys have done? What are your water quality requirements? Sometimes we know, sometimes we don't know. So one of the things we do try to do is find out what your water quality requirements are. Can you provide us a copy of your tribal ordinance? If you have water quality standards that haven't been EPA approved, like Tina works right next to me, so like we can get standards, but sometimes we don't know what you're working on. So we have, for all the ones that we consider it a May effect, we have gone and talked to the neighboring jurisdiction.
And you did bring up something else, Sarai, that I just want to note, going back to your question earlier about, how much information do I need in my objection or what's supported? The clock is ticking in the neighboring jurisdictions analysis as well. So Sarai mentioned when EPA is doing its analysis, we have 30 days to make our May effect determination. But as Zoe flagged, the neighboring jurisdiction only has 60 days to make sure. So, that's something else that we do. Like, we recognize that as like, there are limitations with that, right? And the information you may have on hand and what's ready. And it's just one of those, again, coming back to like doing the best you can and trying to get, if you have more information, great. Like, that's the story I mentioned. There's different junctures, like getting the comments from the jurisdiction, et cetera. Like, that's the sort of information we are looking for, but I would be remiss not to mention that there is that clock ticking. So keep that in mind as you're trying to get materials put together.
Like, you would probably not be able to go do an entire new scientific study.
Yeah.
So if you had concerns about it, it might be something that you're already looking at, right? Or, EPA certainly, I don't think we'd have the resources to get something together in 30 days to do like a scientific study to figure out if it's a May effect. And that's why the bar is kind of lower for May effect, right? Is that we are not saying it will have, an adverse effect. We're saying it may, and then we're letting you, the experts on your land, make that determination.
Other questions folks have? I know we're like way over, but I'm more than happy for us to answer questions.
We thank you for the effort to involve tribes at this level of the neighboring jurisdiction.
Yeah, we're really excited about it.
Tribes a lot more hours when they go to these meetings.
Absolutely. And like I said, what's cool about the new A2 provision with the actual QR code that more than ants can read, unlike our last slide, it is a different A2 process. As I've told folks, it's a little bit more akin to like when you go through the task process for 106 or 319, like the grants program, because this is a non-regulatory task provision, which at least for like EPA, that means something to us in terms of like evaluating the package and getting them approved through the agency. So just wanted to flag that it is, it is a really great opportunity to ensure that you're able to have a seat at the table when these projects come through. Zoe mentioned that or Fatima, you'd mentioned the certified authority. Remember, when they do their certification, they don't have to think about the neighboring jurisdiction because that's not the test Congress put before them. All that the certified authority has to think about is, will it comply with my water quality requirements, yes or no? And there could be real impacts from that on another jurisdiction. Maybe you have more stringent requirements. Maybe there's a use you have that they would never think about, right? But this is an opportunity to get to flag that and ensure that it is being considered in that licensing or permitting process. So definitely, folks, if y'all have questions about the task process or more about A2, I know you are in good hands with our Region 9 colleagues. They're excited about it. And of course, we have our headquarters inbox. We're always happy to answer questions as well. So thanks so much, you guys.